issues there. I think I keep telling people I'm like a 95-year-old woman when it comes to technology, and that really is actually quite an insult for 95-year-old women. So, and the other thing, being around laptop, podium, and so far above everyone, oh my gosh, talk about getting sweaty palms and everything else. So I do want to step back though and acknowledge Pat here. He has been an absolute tremendous leader for our state bar and for the state of South Dakota, and he really is the trademark of getting back, and part of this with the nonprofit is exactly that, is trying to give back. So this presentation is titled Entities of Plenty. It's really talking about choice of law, choice of governance, and spin-offs that are now available. And before I get too far in, I do want to again reiterate what Pat said. If you have questions at any time during this presentation and others, please interrupt and let us know, because we want a dialogue here. As Pat mentioned, our current nonprofit law is actually from 1965. That means over 50 years have passed without any substantive changes really being made to our nonprofit law. In case you don't already realize this, the world has changed since 1965. How we communicate with others has changed since 1965. And the business environment that we operate has changed since 1965. As just one example, Avera eCare is the largest and most comprehensive telehealth provider in the world. It reaches 235 sites with at least one of its services and spans 545,000 square miles. And this is also something that I find astonishing. Avera eCare is also working with NATO to help respond to disasters worldwide. This is just one example. I could point to Stanford, I could point to USD, SDSU, School of Mines. I mean, again, this is just one example of how our nonprofits are really the jewels of our state and the fabric of our state. I don't care what it is, the arts, the churches we attend on Saturday, or our final resting place where the Cemetery Association will govern that. It touches every single person in here. And so it is past time that we sit down and have this discussion on are our laws working and what can we do to improve it. And of course, to know where you're going, you want to know where you come from. So as just a background, this act really comes from a model act. And this model act is taken from the American Bar Association, who vets these things on a national basis. And the ABA Association passed the 3rd edition, so there's been 3 editions so far, of the Revised Model Nonprofit Corporation Act. And it again amended it in 2014. If you notice something, people have to update laws as things change. And so again, you see this here on the national level. We see it with our sister states, our neighbor states. The laws have to keep updating to work for our nonprofits. So most states have actually adopted the Revised Model Nonprofit Corporation Act as proposed by the ABA, or at least have adopted it in some part. There's actually over 23 states that have adopted it in whole or in some part, and other states across the country that have said, we're going to pull these provisions in and use them. And it's a good thing to kind of have this uniformity, really for a number of reasons. The domiciles that follow the ABA Third Model Act have the ability to say, here's what it means. We can look at case precedent, we can look at interpretation of statutes. We have this source to fall back on instead of trying to guess what exactly did the statute mean. And another prominent goal, actually, of the Revised Model Nonprofit Act is to say, okay, nonprofits and for-profits, they're very similar, very similar. It's a business. And so what they're doing from the nonprofit standpoint is trying to say, where we can and where it makes sense, let's line that up with the for-profit sections to give them the same opportunities that a for-profit business would have as a non-profit business. Now, of course, there are some inherent differences between a nonprofit versus a for-profit. And where it necessitates that differences, we have tried to account for that because, again, being a nonprofit is really a privilege. And there does need to be some accountability that goes with that. Now here, getting local in our state, where this began was in 2010. So in 2008, it was passed on a national level. In 2010, we said here in South Dakota, again under past guidance, that we need to look at this. And we formed actually a subcommittee of the State Bar Business Law Committee, subcommittee that worked on the nonprofit law. From day one, we tried to include as many nonprofits as we could, and really this was grassroots efforts. So our reach, although we tried very hard to reach, we had limited resources. But again, from day one, so especially some of the players that we knew had to be on board, we tried to reach and contact them and make sure that they knew what was going on and solicit input. The other thing too, we tried to work with the state agencies. So Secretary of State's office, Attorney General's office, Department of Revenue. So all of these, we try to, again, try and work together and collaborate with, because it's important that the new law that we would set forth actually works for those in the trenches. And I will say it's important to know that we didn't want to adopt the Model Act in wholesale. So although the ABA approved something that they thought was a great Model Act, that doesn't mean it's great for South Dakota in all parts. So there was a critical deviation when it came to the liability sections. Our current nonprofit law is absolutely premier as far as our ability to protect nonprofits from frivolous claims, to protect our volunteers, and so absolutely not would we want to take a step back and adopt the Model Act wholesale. So what we did was we said we are keeping, especially the liability statutes, exactly as they are, and thank goodness for modern technology, you can literally do a copy and paste essentially and put it right in the new act and beyond. And I think that's important though, because again, we didn't want to adopt something that was wholesale, and then the liability protections are absolutely a must to keep the current standards in place. After passing through our subcommittee and being vetted for 4 years, and researching other states, things like that, it passed through our larger business law committee, and then it went on to the state bar last year in June and was passed by the state bar of South Dakota. We then recommended to go further and be introduced in the legislature in 2015, and it was introduced. And as Pat mentioned, shortly after being introduced, I think finally some of the feedback started to come up and rise up, and we heard from a lot of people, which is absolutely fantastic. A lot of times I think we're so busy, and I don't know if anyone's had a chance to look at the proposed language, but I believe it's like 170 pages right now, and the bill that was introduced is like 100-some pages. So for our legislators and for our nonprofits, this is a big task to read this and to understand this and to digest this. And for our nonprofits, it's a bit scary because what does that mean? How are you operating? And will this be a good thing for you? Needless to say, after some of that dialogue occurred, it was absolutely necessary that it be tabled. 2 things happened after it was tabled. One, we decided, let's take a look at this and make the tweaks that we need to make it better. And let's go even further from that Model Act. Let's do even more tailoring so that it fits South Dakota. So that was a great opportunity for us. The other thing that occurred is now more time for education. As Pat mentioned, this is kind of a historic situation. We're talking about an act that doesn't exist. It hasn't gone through our gatekeepers of the legislators. But yet, as I mentioned, our nonprofits run the full gamut. We have HOAs to cemetery associations, to hospitals, universities, to food banks. I mean, it, again, runs the full gamut. We need to make sure that it makes sense for everyone. So what does this mean? Well, it means that change is potentially going to be on the horizon. It can be scary for some, and it can be opportunities for others. I think one thing that needs to be addressed is really kind of this nonprofit myth that exists out there. If you haven't noticed, the word corporation does indeed exist in the Nonprofit Corporation Act. And I think a lot of times people kind of think of nonprofits as, you know, a gathering, people holding hands by the campfire singing Kumbaya. But you guys truly are a business for doing good, but a business nonetheless. And so what we're doing here in this CLE is actually asking you to embrace being a business. You guys get to decide what's best for your business. And I think that's fantastic. So we're empowering you to make the decision. So what's right for your nonprofit might not be what's right for the next nonprofit. The current Nonprofit Corporation Act, as it exists, will stay in place. There will be no changes to that. So for you nonprofits that are in existence right now, nothing changes, absolutely nothing. What we're doing is now adding the revised model Nonprofit Corporations Act. So it'll be another chapter that gets added. Again, because this isn't passed through the legislature, we don't know where it will fall, what chapter it will be, but it will be a supplement, it will be an addition to the existing one. So again, you guys are empowered as a nonprofit. Which one do you want to be governed under? If you want to stay the same, that is absolutely fine. So here's what you have to do if you're an existing nonprofit and you want to remain under the existing 1965 Act. Absolutely nothing. So again, nothing. You don't do a single thing, and you are governed under the current Act. Now, for those of you that might be interested or thinking about electing to be under the new proposed Act, then yes, that is going to take some energy and some additional work. Namely, the articles of your entity must be amended and filed with the Secretary of State. You're also going to probably have to, or want to, update your bylaws. So for those of you that want to select yes, as mentioned, you absolutely, it's mandatory. You're going to have to go back and update your articles. Now the articles, when we're talking about that, what does that mean? How much work is that going to be? How much is it going to cost? Will it affect my status with the IRS? So it's important to know that the only thing you really have to do on your articles to amend it is simply add one sentence in there saying that the corporation is now going to be governed under the revised Model Nonprofit Corporations Act. All the other provisions can stay in the articles. That's absolutely fine. The Articles of Incorporation under the new Act, there's about 8 of them, and then there's about 10 of them under the existing. So the current, or the proposed law would actually be less of mandatory requirements. So that's the big thing right there, is that you have to change that. It's $15. That's how much it costs to amend it with the Secretary of State. So I know as nonprofits, you have to stretch your dollar, every penny. But $15 is, really what you're looking at for that on the Secretary of State site. And then again, with the articles, it is such really a minimal change that it shouldn't cost very much on the legal side of things to make that change. Here's the thing too, is that if your bylaws reference the old law, you're going to want to make sure and go through and change that. So the bylaws now reference the new law, the proposed legislation. But again, my recommendation for you would be to take it a step further, and go through your bylaws and actually see where you need to tweak. And one of the things about the proposed law is that it's going to update it to the 21st century. So where you couldn't have electronic communication before, now you can. So you're going to want to go through your bylaws and actually update those and to have for notice provisions, meetings, things like that, and utilize our technology that now exists in today's world. And I know some of these nonprofits, it's a time thing and it's an expense thing, but you got to blow that dust off every now and then and open them up and actually look at them and see, is this how we're running our business? Does this make sense? And are we complying with that? For those entities that are formed after the new law, if the new law gets passed, they will automatically fall under this new law. So they are going to have to make sure that they're complying with the new article requirements and bylaw requirements, and it gives them, again, more options. So for the new entities formed after this would be passed, they, again, would have to be governed under the new law. Now, for those entities that are existing prior to 1965, you have the option again to decide if you want to continue your governance to be under pre-1965 law. So if you want your charter to remain intact, that's absolutely fine. You can do that. And the citation for that is SUCL 4722.2.1. So yes, that means that there's going to be actually 3 different nonprofit laws on the books. Does that get a little confusing? Potentially. But again, what it's doing is really empowering the nonprofits to decide which one works better for me and for my entity. So basically the moral of the story is to make sure you're choosing your law wisely, because now you actually have these options. Comparison of the old with the new proposed. Again, the biggest thing is that it's updating to the 21st century. So when we want to give notice right now, it's pretty much has to be written notice. This would allow for electronic communication to give notice. Meetings, same way, we can now do it electronically. Where possible to, again, those plumbing provisions of the for-profit, we're taking them and using them in the nonprofit. One example is with our for-profit, it is specified if you're filing something with Secretary of State, it needs to be in English. We don't have that in a nonprofit. So it's simply devoid in certain areas that make sense for governance, just to make sure that everything's clear, we don't run into any issues, and that it stays the same. Matters relating to setting a record date, voting agreements, all of that is going to be mentioned in the new nonprofit law. So right now we don't have some of those options. And again, the new law would give us that ability. Minimal changes to the articles. Again, actually lesser mandatory requirements, more optional requirements or optional provisions that you can put in. Same with the bylaws. One thing on the incorporating side, I think it's important to point out, where you need multiple parties now to form a nonprofit, you're only going to need one person to organize a nonprofit. So that will, again, align with the for-profit section. And again, it just simply has fewer mandatory requirements in the bylaws, and it's very similar to what's existing today. So there would be minimal changes that would be needed to be made. The filing, service, and copying fees, again, that actually remains the same. We worked very closely with the Secretary of State's office, and they were adamant, let's keep it the same. We need to keep it affordable for nonprofits. Whereas, especially if you look at our neighbors, we're one of the cheaper states for nonprofits for filing purposes. And the Secretary of State's office said, no, we're keeping it. We're not raising those by any stretch of imagination. So those will stay the same. And then, as mentioned, the big deviation, again, is for our liability provisions. That is going to stay the same as it is now. It's going to be pulled over into the proposed nonprofit law. The power section is also different. The power section now is fairly minimal, and it's really, here's the powers, period. Under the new law, you have a lot more powers given to you, and you can actually limit those powers within your own bylaws. So if you wanted a limited range, you can now have that ability to do that. In comparison, again, with the comparison with the old with the new, really it's like looking at a skeleton. Right now, we have a skeleton for nonprofit law in our state. The proposed act would add organs, muscles, and flesh to it. And I think that's so important for everyone to understand. The existing law does not address domestications, conversions, derivative proceedings, membership exchanges, and transition provisions. Nor does it mention even a standard of care. This is simply absent in our nonprofit law. Yet it is available in our for-profit section, and it is available in the proposed revised model Nonprofit Corporation Act. So with domestication, I think this is interesting. If you wanted to domesticate right now in South Dakota, you really couldn't. You're going to have to merge, or you're going to have to close your shop and open a new one in South Dakota. So you don't even have that option. And that's a big deal in our mobile society with people moving and with, honestly, I mean, nonprofits and businesses have to foreign shop. We're not even really an optional entity choice because we don't have that availability to domesticate in South Dakota. Under the proposed law, you would have that ability to domesticate. And that's the same for conversions. And again, in today's business environment, whether for-profit or nonprofit, people are very cognizant about different business opportunities and different liability opportunities and protections that need to be there. And so you will see maybe one entity form another entity or spin off into another entity. With these conversion statutes and the proposed legislation, it will now allow a for-profit domestic South Dakota entity, nonprofit entity, become a nonprofit South Dakota entity, and vice versa. So if you're a nonprofit entity and you want to add a component to the business that really is in for-profit nature, you now can do that. You can now have that ability to convert for-profit to nonprofit and vice versa. And the other option that's available too is now if you're foreign and you want to come in and domesticate, you can also convert at the very same time to for-profit or nonprofit. So this just opens up the door of opportunities for our nonprofits in our state to have the right type of business entity, the right type of laws. So I think it's very important to understand. Again, the derivative proceedings, it gives out members the options. We have those options for members of for-profit, so why not nonprofit? And the same with membership exchanges and those transitional provisions. And on the practical side of things, on the practitioner side of things, when you're doing that, it's nice to have that legal guidance. When it's not there, we're just kind of guessing what it should look like. And we're hoping we're doing the best. But when it's there, we can all take a deep breath in and say we're following this exactly as it needs to be. So that is, I think, very important that things are going to become more black and white and give us that guidance. Attached to my materials in here, you're going to find an Appendix A. This is a cross-reference section from the existing law with the proposed law, the proposed revised Model Nonprofit Corporation Act. This goes section by section, comparing the old with the proposed. And I think that's important to understand that one of the things we need to have on our learning curve as far as introducing to legislature, people wanted to know what does each section really do. And so here's the work that we've been doing over this since really about February in trying to put this together. The subcommittee on the business law committee is the one that did this. And I'm attaching in my appendix so that we all have it. But again, I don't want to take credit. That was our subcommittee work that did that. The other thing too is that this proposed bill, the draft that's currently attached is on our website. So that's at, again, www.sdbar.org. So we talked about choice of law. Again, we're trying to empower the nonprofits. Which choice of law do they want? Now let's move to choice of entity. Right now in South Dakota, there really is no entity choice. If you are going to be a nonprofit in South Dakota, your option is to be a South Dakota nonprofit corporation. However, under the proposed law, what we're saying and what we've changed is that now we're going to give you a choice. Do you want to be a corporation or do you want to be a South Dakota nonprofit limited liability? So I think that is absolutely huge. This does not, again, impact your tax status with the IRS. If you're switching entities mid-game, yes, there's different requirements. But as far as when you're going to select that, on the 1023, the IRS already allows you to select, are you a corporation or are you an LLC? But yet our laws don't allow that. So you can register, again, do that 1023 with the IRS for your tax status purposes. You can do that. But you wouldn't be falling under our South Dakota Nonprofit Corporation Act. So So you are missing out on the great liability protections that we have for volunteers and for nonprofits in our state. And that's really unfortunate. So this cures that problem. It gives nonprofits that ability. The other thing is that with our nonprofits that own real estate, the entity of choice is your limited liability company. This now gives you that ability to do that. So if you're a nonprofit that has real estate, you should definitely look long and hard at this option. And then just trying to cover some practical information here really briefly at the end with the old and the new. Constitutions, we get this question, especially with our religious organizations. Under the old, or current, I should say, and the proposed new, you can have whatever you want to call it for your organizing governing documents. So if you want to call it bylaws, constitution, or have multiple or both, you can already do that, and that won't change. The other thing is committees. I see this all the time, where nonprofits don't have 2 board members on a committee. It's 2 right now. So you don't have to, go back and make sure you're correcting that. Under the proposed law, it will just be 1, only 1 committee board member